Hi, my name is Katie Vilkin, and I will be presenting a case analysis on BMG rights management versus Cox Communications. This case centers around internet law, copyright infringement, uh, and what constitutes as a valid safe harbor claim under the Digital Millennium Copyright Act. The defendant in this case is Cox Communications. They were founded in 1898 by James Middleton Cox, who had a passion for newspapers. He acquired several newspapers, 4 radio stations and 2 television stations. They were able to procure 3 cable systems in the 1960s, and this enabled them to provide antenna TV to over 11,000 customers. And this created a significant growth for them throughout the 70s and 80s. Today, they are still a privately owned, family-owned company. They operate several sectors, such as Cox Communications, which is the internet service provider in this case. They also operate Cox Automotive, Cox Farms, and Socium Ventures. They claim to generate $23 billion in revenue annually, and they employ 50,000 people worldwide. The plaintiff in this case is BMG Rights Management, which is a music company that specializes in managing music publishing and record rights for songwriters, artists, and producers. And this allows them to collect royalties and license their music to commercials, TV shows, and movies. This company was founded in 2008 and is the 4th largest music company in the world. Their BMG Next strategy allowed them to align with Spotify and Apple Music to stream their artists' music exclusively, and this streaming accounts for 68% of their revenue. They also aligned with Universal Music Group, which physically distributes their music, and they credit this strategy for their 37% boost in EBITDA and their 8.1% organic growth. So the legal focus, like I said, in this case revolves around internet law, the Digital Millennium Copyright Act, and the Safe Harbor Act. The key issue here is that BMG sued Cox for failing to address repeat copyright infringement by Cox's subscribers. The Digital Millennium Copyright Act, or DMCA, protects owners of copyrights in digital information such as songs owned by BMG. Several of Cox's subscribers use a technology called BitTorrent, which allowed peer-to-peer networking that enabled users to access and download copyrighted music. Now, BMG claims that Cox knowingly allowed their subscribers to share and receive BMG's copyrighted music files. Cox Communications functions as the internet service provider that enables their users to access BitTorrent's features. In Cox's defense, they claim that they implemented policies that qualified them for safe harbor protection. And safe harbor protection can be granted to ISPs, which limits their liability from contributing to copyright infringement. Now, this protection only applies to ISPs that were unaware that copyright infringement was taking place. Moving on to Cox's defense. So in order for Cox to claim the safe harbor protection, like I said, they must effectively implement a policy that suspends and or terminates repeat copyright infringers. Cox first presents this 13-strike policy that, in my opinion, falls short. So each strike counts as a copyright infringement notice. The first 10 strikes were only warnings issued to their subscribers. No suspension or termination took place. And on the 11th, 12th, and 13th strikes, the user was suspended and only needed to call a Cox technician to reactivate their services. So the user wasn't even considered for termination until the 13th strike, and even then the termination seemed up for debate. Next, Cox ignored violation notifications from this company called Rights Corp, which is a third-party company that monitors BitTorrent activity and notifies ISPs of any copyright infringement that they find. Now, Cox blacklisted Rights Corp because of some settlement language they didn't agree with in their notices, and BMG hired Rights Corp after Cox had already blacklisted Rights Corp. So this essentially eliminated Cox's ability to review and take corrective action against users who shared and received BMG's copyrighted music files using Cox's services. And finally, they had a financial motive Of course, Cox executives, it was found that Cox executives sent emails to their subordinates stating to hold off on suspending and terminating certain high-paying subscribers because they paid large subscription fees. And furthermore, Cox would always reactivate suspended or terminated customers after only a short time and claimed that the user was terminated, therefore their duty as an ISP was fulfilled. The courts ultimately disqualified Cox from using the safe harbor claim, and they found them liable for contributory copyright infringement. They found that the 13 strike policy was inefficient in terminating these repeat infringers, and they also found that Cox failed to follow their policy in a meaningful way. So because, I'm sorry, because Cox blacklisted Rights Corp, they essentially prevented themselves from reacting appropriately to copyright infringers and the notices. So for the previously mentioned reasons, Cox did not qualify for protection. And I agree with the court's decision because first and foremost, it's clear that Cox prioritized their revenue over their own policy, and they showed that they terminated repeat infringers only as a symbolic gesture, only to reactivate them shortly after. And I found that the 13 strike policy was far too lenient, especially considering that no matter how many copyright notices Rights Corp issued for a subscriber, Cox sent a maximum amount of 1 notice per user per day. And finally, blacklisting Rights Corp definitely disqualified Cox from protection under Safe Harbor because as an ISP, they have a duty to terminate repeat infringers, and they can't do that by knowingly avoiding notices sent exactly for that purpose. And the impact of this case, so the trial courts originally ordered Cox to pay BMG $25 million in monetary damages, but the appellate court vacated that because of an issue with jury instruction in trial court, so they sent back the case, sent it back to trial. Now, it's alleged that Cox and BMG settled outside of court for an undisclosed substantial amount of money, and I'm just going to go ahead and assume that Cox paid BMG because of how the court ruled. Nowadays, Cox and other ISPs are being sued by other record companies for the exact same reason. And this case reinforces how Safe Harbor under the DMCA protects ISPs and shows that ISPs must implement meaningful policies and follow through with them. It's not enough to terminate an infringer and reactivate them a month later for the sake of saying they were terminated. There's no rule saying I can't reverse that termination. So the termination must remain meaningful for an ISP to be protected under Safe Harbor. Otherwise, the ISP wouldn't be fulfilling their duty to protect copyrighted materials. And these are my references. Thank you for watching, and I'm sorry I went over a few seconds. It's a lot of information, and I feel very passionate about this.